Okay, let's go on the record on cause number DC 1920600, Holly Henson versus Tyler Smith. Council, make your appearances.
Marilee Lewis on behalf of defendant Tyler L. Smith.
Gregory Shamoon and Stephen Tittle on behalf of the plaintiff, the respondent, Holly Henson, Henson.
Okay, you may proceed, Ms. Lewis.
Thank you, Judge. May it please the court. Judge, we have filed a motion for continuance and a request to abate the proceedings. I have filed with the court coordinator and provided to the court specific exhibits in support of our motion. This is a case that initially began as a suit affecting parent-child relationship in December of 2019, and the case was filed in the 302nd District Court. The case was actually filed in that court on or about December the 9th, 2019. Subsequently, on December the 31st, 2019, Ms. Henson caused to be filed a civil action in this court. It is defendant's position that the cases are so interrelated and contain such common areas of fact and common parties that it...
Ms. Lewis, I guess my question here, can you hear me okay?
Yes, sir.
My question here is, why is this being filed in my court as opposed to the family court? They were the first filed case, and with the local rules, they would make this decision.
And Judge, if I may, thank you for cutting to the chase. I appreciate that. If I may, Judge, on January the 27th, 2020, my exhibit D2 is a copy of the motion to consolidate and transfer that was filed in both the 302nd and the 68th District Court. In an abundance of caution, I filed it in both courts. We have been able to get a hearing in the 302nd. The problem with the hearing in the 302nd is it post-dates the trial setting in this case. We have an initial trial setting of July the 20th. Due to COVID and some other factors, we've had difficulty getting some setting dates. We finally were able to secure one, but the first available setting on the motion to consolidate and transfer is not until August of 2021. And that's the problem, Judge. We would like very much for these to be
So you filed this over a year ago and you just got a setting now?
Yes, sir.
When did you first request the setting?
And Judge, we have requested a setting quite some time ago. I don't have the exact date of the request. I do show that we have also filed an amended motion to consolidate and transfer. The problem is, as I'm sure the same problem the court is having in the 68th, is that there are prioritized hearings that must be held. And so naturally, those are being given a little bit more priority than the motion to consolidate and transfer. The trial setting on the 20th of July in this case, in your court, is the first trial setting. It is the initial.
Are you familiar with the new case out of the Dallas Court of Appeals in the Fisher case?
No, Judge, I don't believe I am with that style.
It's a very similar case to what it seems like is here. They're not identical. Where Judge Wysocki, who I'm sure you're familiar with, when she was in the family court, she transferred a case involving the Fisher family. I'm sure you're familiar with the Fisher family. The commercial portion of that case, there was a family law portion and then a commercial portion, and it was transferred. She transferred it. I agreed with her, actually. I thought she was right. She transferred the commercial case from my court to her court. Court of Appeals reversed her, saying that she didn't have jurisdiction. It sounds very similar to what we have here. If Mr. Shamoon, anyway, So I don't know if anyone has looked at that case, but it may be different. I don't know enough about what this case is about as opposed to the family case, but they've made it very clear that the family court should only hear cases involving cases arising out of the family code. I don't have the terminology exactly right, but essentially that's what they said. So I think that would be really critical to look at before we make any decisions here. Mr. Shamoon, are you familiar with that case?
I am, Your Honor. The family court does not have jurisdiction over this case, and let me tell you why. The parties were not married. They've never been married. There is no divorce proceeding in the family law court. There's only a SAPSR proceeding related to visitation and child custody and rights and duties of parents, not spouses. In addition, this is a tort case where it's been alleged, and trial is Tuesday, and the trial, we've shared exhibits, we've shared witness lists, we've complied with the pretrial orders, some of us timely, some of us not. The bench trial, in our opinion, will last no more than a day, Tuesday, and we are first on your docket.
No, you're not anymore, but just FYI, yeah. But things have changed quite a bit in the last few weeks, but we'll talk about that in a second. But go ahead.
Last week, Judge, I call her Judge Lewis. Judge Lewis filed a request for a hearing last week in the family court on the consolidation after the case has been filed for, gosh, going on 19 months. And again, we do not believe that the questions of law are the same as in the SAPSR case in the lower court, in the divorce court, the family court, and we have a tort claim here in the district court. And so there's, will there be some overlapping facts? Of course, there always is when there is at least two people that know each other and have had a relationship. But as it relates to the assault case, I don't believe the court has jurisdiction in the domestic relations court, Your Honor, over that cause of action.
And Judge, if I may respond, again, I am not familiar with the Fisher case. I am more than happy to take a look at it. But as I'm sure this court is familiar, the Supreme Court of the state of Texas has held that in family law matters, the court may hear tort causes of action. That was specifically addressed in the Schluter case. So I think that it's well-established law that the family courts can in fact deal with tort claims as well. With respect to filing a request for hearing on the motion to consolidate, what was filed last week was our notice of hearing, not necessarily the request. We did get a notice of hearing in the family.
You're going to send the notice of hearing out at the same time you do the request, aren't you? You're not going to get the hearing and then tell them about it 2 months later, right?
Oh, we have to get a variety of dates, Judge. In the family court, they do things a tiny bit different. We ask for a number of different dates. So we have to check and see what the court has available. So that we do things just a little bit different over there.
Okay.
But no, I'm not going to not give Mr. Shamoon notice.
I don't think that was the case. I guess my thought on this is really the family court's decision. If they want to abate my case or if they want to consolidate it, it's not my role to do that. My feeling is we just kind of move forward, and if they want to stop us, they can stop us, and then the Court of Appeals can tell them if they're right or not. I will say this, Mr. Shamoon, is let me kind of give a kind of big picture here, is that, for 2 months, the courts have been on a rotation where each judge got 1 day for jury trials. And my day was going to be the 19th of July. I had a date on the 23rd of June where we tried actually 2 cases. And then we had a day to select juries that was supposed to be July 19th. Judge Moore, our local administrative judge, has just announced recently that we are going off of the rotation system and going back to regular jury trials. Because I believed on the 19th that was going to be my date, I set 20 cases for trial to make sure I got at least 20 jury trials. So we have 20 pretrial hearings on the 20th, on this Friday for Monday. So it may look like you're number 1 on the docket, but unless all of those 20 cases go away, you're pretty unlikely to get reached. And so I'm not going to abate the case. I'm not necessarily going to continue the case. I just want to be honest with you that I don't think you're going to get reached, but that's, that's the situation.
Judge, the trial on Tuesday was a bench trial. Does that make a difference?
Not really. We're in the middle of hearing, so I can't hear anything. It's okay. It's okay. Guys, thank you guys.
So Judge, if I'm understanding correctly, you're saying you're going to be calling your jury docket on Friday?
So on Friday, we're going to have 20 pretrial hearings involving our 20 jury trials. They're all set for Monday. Usually I call my docket on Tuesdays. I know this is a little confusing, but usually I call my trials on Tuesday. Judge Moore assigned me to that Monday, and I wanted to get I kind of liked it because I wanted to get as many trials done next week as I could when I thought I was going to be the only case called under this rotation system. Now I don't know how that's going to work exactly, but we have 20 pretrial hearings for jury trials on, currently at least, last time I looked, for Monday. And then my regular Tuesday docket, I guess there was some non-juries left over. And I guess this case was one of them. That's the situation. It's whether or not this non-jury will go will really depend on if we finish all our jury trials on Monday. I would be pretty surprised if that happened. It's not impossible, but that's the situation. And so it's going to be challenging to be honest, once we start jury trials, for us to really do a non-jury case for a while. So just FYI about that, we don't have any jury weeks until December 28th. In the George Allen, Judge Lewis, you probably remember we used to have jury and non-jury weeks. And now the rest of this year, because of COVID, we don't have any non-jury weeks. So we're basically looking at a situation we're going to have just jury trial after jury trial after jury trial. That being said,
so Judge, let me make sure I understand what you're saying.
Yeah.
We couldn't get a non-jury trial where this case would take less than, without a doubt, 1 day in this year? One day.
So I have one option for you. If you can promise, if you can agree to time limits, I have one date that I'm going to basically make a non-jury date. And that's just because of my schedule. If you could guarantee me you could get this trial done within 6 hours, I could set it on September 14th as a special setting if both sides agree. And that would give you a chance to hopefully have your other hearing. I mean, I'm not going to continue the case. I'm just trying to be honest with what my docket is. I don't necessarily agree with Judge Lewis that this case, I think this should have been decided by and I think this could have been heard by the family courts. But the reality of the situation is we've not had jury trials for a year and 3 months, and we're starting them next week. It's going to be tough. And so if you could guarantee me you could finish it in 3 hours aside, I could do it on September 14th if y'all wanted to do that. And that's only because of the situation involving my personal schedule. Otherwise, we could set you on December 28th. I can set you any other week, but you're going to be behind all the jury trials. And I just have a feeling that all the other weeks we're going to have so many jury trials that we're not going to be able to reach you. So that's the one option. But again, I don't mind. I'm super flexible. I'm just trying to tell you what the situation is.
Judge Lewis, will you agree to that?
I think that we're going to need a full day, which I anticipate is 6 hours. The only concern I have is I do need to check with my client about his availability for September the 14th. He's an attorney as well, Judge, and I would hate to commit him. Could we have until tomorrow to check on that?
Sure.
Day or later today?
You can have as much time as you want. I mean, not as much time as you want, but yeah, that's fine. Tomorrow I'm starting up a non-jury case, but since it's the week before we start our flood of jury cases. And so, but we do have a Zoom link that's up if you want to go ahead and get that from Rhonda. You guys can show up, talk about it. One thing I would say to your client is that as an attorney, I'm going to try to give him some degree of, certainty, but with the way that our docket is, this is the only kind of date I can give him with any degree of certainty that it will go. And is he the plaintiff or the defendant, your client?
He's the defendant.
He's the defendant. He might think, well, I just want to put this off and put this off. If it comes down to it and I'm available to try the case, I'm not going to necessarily, if he happens to be in, Nova Scotia, I don't know why I picked Nova Scotia, but Nova Scotia with his kids, there's Zoom in Nova Scotia. He's trying this case. I had that come up last week where the parties wanted a continuance because they were going to be on a trip. And I'm like, hey, I was trying cases last week while I was in Durango with my in-laws. It's the nature of the beast at this point. So it would give him some degree of certainty and probably be more convenient for him if he could agree to that date. But that's the only date I have that I can give you guys for the rest of the year that would have any degree of certainty.
And we will agree to it. We'll wait to hear from Judge Lewis by the end of the day. Judge Lewis, is that fair?
Tomorrow. I'm in mediation right now, and I've
Okay.
stepped out of mediation. So if I could have till close of business tomorrow, Mr. Shamoon and Judge Hoffman, I can certainly check with my client this evening when we finish and let you know tomorrow. And if it's agreeable to my client and Mr. Shamoon, can we just give the court coordinator notice and send a new notice of trial date?
So what you'll do is you'll just email her that you guys have agreed to the special setting on the 14th, that you've agreed to 3 hours per side and you've agreed it's going to be a non-jury. And then if you don't agree, if he doesn't agree, then you're still set for trial next week and you're just going to ride the docket.
Yes, sir. Understood.
And Judge, thank you so much for your time. Little housekeeping. We've prepared and submitted a order denying the continuance and the abatement. Would the court be so kind to entertain execution of same for our files?
You want me to deny the continuance at this point until we hear from Ms. Lewis about it? Or I don't mind denying the abatement, but if I deny the continuance, then you're stuck on the trial docket next week.
Then don't do that until we hear from her. Thank you so much for clarifying, Judge Hoffman.
Yes, thank you.
Thank you, guys. You guys be safe. It was good seeing both of you. And just let us know as soon as you can, Ms. Lewis, about what your client decides, okay?
Yes, Judge, I will. And thank you very much for your time. May we be excused?
You may. Good to see both of you.
Good to see you.
Oh, okay. Thank you.
Y'all have a good one.
All right. I think we have one more hearing. So are both sides here in the RAE Austin Holdings versus Whitmore construction case?
Amanda Swartz, I'm here on behalf of the plaintiffs.
Garrison Lipscomb on behalf of defendant Whitmore Construction LLC.
We've got a bunch of folks here for third-party defendants as well, Judge, including me, here for Procal Stone.
Okay. You guys are set for trial on October 5th, is that right?
Yes, Ron.
All right. So Ms. Schwartz, you're the plaintiff's lawyer, is that right? Or defense lawyer?
Yes, Your Honor, plaintiff's lawyer.
And Mr. Harrison, you're one of the defense attorneys?
Third-party defendant, Your Honor, that's correct.
And Mr. Lipscomb, you're one of the are you the defense attorney?
Defendant, third-party plaintiff, Whitmore Construction LLC, and I think Mr. Montez is here as well for Whitmore Global LLC, one of the other defendants as well.
All right, so we have a hearing, we have a trial setting for you guys on December 15th, but you guys wanted I think a scheduling conference, or did I set this?
I did, Your Honor.
Okay.
Well, I'm not going to claim to have been part of this process full time because I'm really relatively new to this case. But I have been trying to get written discovery done and to set some depositions. And I've got an agreement from all parties except for one to conduct depositions in any written discovery. And it's all, we also had a proposed agreed scheduling order. And again, we've got one party that won't sign it. Everyone else has agreed. Basically, I feel I'm in a position where I don't have written discovery. I can't get depositions done.
Okay, go ahead.
Okay, sorry. And I've got 2 pending MSJs now without any written discovery from one party and without the ability to take any depositions. So that's what I'm really looking is for a manner in which to actually get this case to trial. I just need to get the discovery done. And we've been going back and forth for months on this. I just didn't really see any way to get this settled and moving except for coming to court on a scheduling conference.
Okay, who's resisting?
Good afternoon, Your Honors. Steve Tittle for defendant, Stonecoat of DFW LLC. Sorry, it took us a minute to get our Zoom link back after the last hearing.
Okay.
We are resisting it. The reason we are resisting it is because we're not a proper party to this case. We had this case scheduled for trial last year after discovery closed. Plaintiff and the other defendants were fine with moving the case. We opposed that. The court granted their request for continuance and reset it for the end of this year. For months and months, neither plaintiff nor the cross defendant who sued us served any discovery request on us. Discovery was still closed. Then plaintiff served a batch of discovery requests on us. Well, 6+ months after discovery had closed, and we objected on that basis. They want to reopen discovery. I don't know if they want to postpone the trial as well, but we filed no evidence motions for summary judgment, which are scheduled in the court in about 1 month. And we object to it. It's a capacity standing issue that if they had any evidence that we had ever entered into an oral or written contract, we would continue talking with them. But we agree the no evidence MSJ and the traditional portion are right for the court to determine, and we do oppose reopening discovery roughly a year after it's already closed.
Ms. Schwartz?
Your Honor, based, as I said, I could be stating this wrong because I have not been involved in all the discovery going back a year. Generally, a case is continued because additional discovery is necessary, and that's a general problem. And so I don't know if there was just no scheduling order thereafter entered, but that's kind of what we've been trying to do now, is that we know we're going to have a later trial date. We know there's discovery that needs to be done. So we've all just kind of been trying to work towards that. So I know a lot of the delay has been based on that, at least for the last few months while I've been a part of it, is that we haven't been able to get something in place. I think that everyone was kind of pushing this down. Now things are opening back up, discovery is going out, we're setting depositions. And I just don't think I just don't think, and I understand that its issue is standing. I have some kind of fact questions about that. I'll address that in a motion for continuance or MSJ hearing. But in a general sense, we have no discovery of this case. And all the parties except for him have agreed to a scheduling order, to a trial date, to conduct depositions, all of these things. So we're
So
basically,
can any of the other attorneys kind of reference why there wasn't discovery done during the discovery period? Mr. Lipscomb?
Looking back through the file, Judge, it looks like there was discovery that was issued right before a new trial was set for this October, which looks like that was issued right around December, which kind of looking at the timeline, it coincided with whenever defendant Stonecoat's responses would have been due to, our discovery requests. And then the trial setting gets moved until now. And I know since that time that there's been other discovery. We've conducted other written discovery with other parties. We tried to get depositions set. Then those were subsequently quashed. Those were quashed immediately by defendant Stonecoat. And then after that time, since their position was that discovery had been closed, then we tried to circulate a new scheduling order that would then allow us to, kind of formally have the discovery reopened to continue discovery and have depositions without the need for kind of the formal quashing of the motions. And then we've just continued to not be able to come to any sort of agreement with defendant Stonecoat to agree to the new dates that we circulated. And we did circulate a new trial setting, but that may need to be revisited now, even if we were to continue this current October trial setting. So we kind of have agreement from all parties about a new trial setting, which would also reopen discovery to conduct depositions, do expert designations, finalize the written discovery that we need. But we just haven't been able to get agreement from defendant Stonecoat. And then when this hearing was set, defendant Stonecoat then filed their motions for summary judgment. Within those motions for summary judgment, they included an affidavit that then referenced the correct Stonecoat entity that perhaps may be the proper party instead of Stonecoat DFW, the current defendant. So it's just been a long process to kind of get to where we are.
And I don't know if anyone will know the answer to this. Then did anyone ever send any requests for disclosures to Stonecoat? And did anyone send requests for disclosures to them prior to the discovery deadline closing?
I believe so, Your Honor. I will try to confirm.
I mean, because they should have disclosed the correct entity at that time, right?
Yeah.
Did they do that?
I'm looking at September 11th, 2020, I believe, that they were served.
And what was their response to that? Did they disclose this party or not?
Your Honor, I'm looking at the responses that I can find, and I do not see.
Your Honor, I
where-
don't see that they disclose it.
Did you guys disclose this other party when you answered requests for disclosure?
Your Honor, if you'll give me just one moment to look through the file. Our client in his affidavit stated the same as we disclosed, which is we have not signed an oral or written agreement. We know that there had been another Stonecoat entity that plaintiff had dealt with. It's our expectation that that's who they entered into a contract with. But as far as our defense,
Can you share screen the request for disclosure responses so I have a feel for what was exactly said? Can somebody do that? Oh, I may not have enabled it. Let me see. Okay, now you can go ahead and share screen, Ms. Schwartz or Mr. Lipscomb or whoever.
Garrison, are you doing it? You do it?
No, I thought I had it. Now,
What? Sorry, Your Honor. I am not the best at technology.
did too, but I think that was our responses.
Everyone see this? Or is it just me?
Yeah, I need their responses to discovery.
Oh, sorry. Wrong person. I can get that up. Sorry, I'm gonna stop this real quick.
Your Honor, I was having someone try to find the petition to see if they had requested disclosures.
I mean, this is to me,
Your Honor, I don't see the responses by Stonecoat to request for disclosures in my discovery file. So they must have not been sent to Stonecoat. What I do see is that the original answer of Stonecoat does not have a verified denial. That's from February of 2021, but it's their first amended answer here, June 8th, 2021, that they raised the issue of lack of capacity as a verified denial. But that's
Your Honor,
after.
I didn't want to represent anything to the court until I saw the pleading itself. I don't believe that plaintiff requested disclosures from Stonecoat. I'm trying to verify that at the moment. Additionally, we followed a general denial as all we're required to do. When we got an affidavit, when we supplemented or rather amended our answer, we amended our answer to say lack of standing, lack of capacity. We filed our no evidence in traditional MSJ, and then the other side wanted to reopen discovery and set this conference.
I guess my thought on this, and this isn't a ruling, but it's just my initial thought, is that probably the correct procedural mechanism, and I don't think that you filed one, but I can double check. Have you filed a motion to reopen discovery?
No, Your Honor.
I think that would probably be the correct or motion for leave to take discovery or something to allow me to to deal with this. If discovery is officially closed, I don't know that I want to just enter into a new scheduling order unless all parties agree. I do think it's important to know, in my mind at least, if you guys sent over, and it sounds like Ms. Schwartz, it wouldn't be your fault necessarily, you weren't on the file, but your predecessor counsel didn't send over requests for disclosures prior to the statute of limitations running. They could have found out that there was another entity. I understand the argument about verified denial and all that kind of stuff, but that is something that's going to be important for me in the future to know what exactly happened there. But I think at this point, the appropriate thing would be to file a motion to reopen discovery, and then we can kind of deal with it at that point.
Okay. I know you talked about your docket, but do you know about how long it's taken to get hearings in your court? I know
Hearings are not as much of a problem. Because we do hearings on Monday. I would suggest you try to set this on a Monday. We have a Monday docket that's all day. It's exclusively devoted to hearings, unless I'm ill, which almost never happens, and knock on wood. Then that will go forward. My Friday docket is going to be subject to trials, and with the new jury trials starting next week, I'm pretty concerned that a lot of those Friday dockets are going to get canceled. And so if you want to get something set, it's a little more certain. During COVID, we almost always did our Friday dockets. There was a couple of times when we had trials go that long, but generally we didn't, because our non-jury cases don't typically last that long. But I urge you to look at a Monday, and I would guess 3 to 4 weeks you can get something set. Is my guess.
Okay, perfect. I appreciate your time today.
All right. Anything else, guys?
No, Your Honor.
Thank you, Your Honor.
Thank you,
All
Judge.
right. You guys be safe. It's good to see everybody.
Thank you.
And
You
we'll see
too.
at the next one. Okay. Thank you so much.
Thank you,
Bye-bye.
Your Honor. Bye-bye.
And intern, stay on. Okay, let me go ahead and turn off YouTube.